An appeal against an arbitration award under Section 69 of the Arbitration Act 1996 is, as we all know, a two-stage process. Stage one is where the claimant or the appellant has to seek to obtain permission to appeal, and to do that it has to satisfy the requirements of Section 69, subsection 3. If the claimant succeeds in persuading the judge at that hurdle stage, then stage two then follows. And that is the full appeal hearing, where the question of law in issue, for which the court has granted permission, is then considered by the court. But to what extent can the respondent who has resisted permission at the permission stage, stage one, and has failed, to what extent can it seek to resurrect at the full appeal hearing the alleged failures to meet the Section 69(3) requirements, which the court has just rejected? That question is addressed, and was addressed very firmly, by the Commercial Court today in the decision CVLC 3 Carrier Corp and Arabian Maritime Petroleum Transport Company, in which I appeared for the successful appellant. And in doing so, the court, Mrs. Justice Cockerell, also gave very useful guidance on one of the most important of the Section 69(3) requirements at the permission stage, namely the need to show that the question of law on which you seek to appeal was, open quotes, one which the tribunal was asked to determine, close quotes. The point came up in this way. AMPTC was a guarantor. CVLC arrested one of its ships, alleging that the guarantor was in breach of the guarantee. The guarantor alleged that there was an implied term of the guarantee that prevented CVLC doing that on two bases. One, as a matter of construction of the guarantee, and two, because of 5 factual matters which it said led to an implied term. CVLC disputed both points, but in particular said that the factual matters were disputed and couldn't be dealt with by the arbitrator. The reason for that was the arbitrator was being asked to deal with the matter on an urgent, documents-only basis. The arbitrator found for the guarantor and found that there was an implied term that's now been overturned, and did so only on the basis of construction, because the arbitrator held he couldn't get into the facts because they were disputed. CVLC then sought permission to appeal on what they said was the question of law, namely, was there an implied term? AMPTC resisted that, saying that wasn't the question of law which had been determined by the arbitrator, which was an implied term on the basis of construction and facts, and he determined a different question. A slightly curious approach, given the fact that they were the winners in the arbitration. The judge found that the question formulated by CVLC was not quite the question which he'd been asked to determine, and the court reformulated the question for itself and granted permission on that basis. At the full hearing, the guarantor returned to the fray and said now that not only had the arbitrator not been asked to determine the question CVLC said he'd been asked to determine, but he hadn't been asked to determine the question which the court had said had been left to him to determine. The highly technical point, as the judge found. And the judge said, first of all, that it was necessary to look at the question of law in a pragmatic way to see what, in essence, the real question of law which had been left to the arbitrator was. And she found the real question of law was whether there was an implied term that prevented the obtaining of security from the guarantor. And as she put it, it's necessary not to lose sight of the macro question, because by focusing on the details of how the question was precisely put in the pleadings and the written submissions, it often risked obscuring what the real question was that the parties had left to the arbitrator to determine. The other important part of the decision was the judge reviewed the cases on resurrecting Section 69(3) at the appeal stage 2. And she found that the court technically had jurisdiction to revisit Section 69(3) requirements, but that for policy and case management reasons, that was a course that should be only most exceptionally undertaken. She stressed that it would only be, in her words, a highly unusual case when there were highly unusual circumstances justifying such a course of action, that it would ever be appropriate for the court to go back over the Section 69 questions which it had already dealt with in granting permission to appeal. And as she said, to allow the revisiting of the Section 69(3) stage from stage 1 to stage 2 would be to undermine the policy of the Act which have expressly created a two-stage process to have one hurdle out of the way and then on to the appeal proper. A robust and timely decision showing that the English court is astute in the interests of keeping the Section 69 appeal procedure as strictly regulated and as lean as possible. So the moral of the story is there are no second bites once permission is granted, and the focus at the appeal stage is on the question of law and nothing else. Thank you very much.